Welcome back to Law and Crime, everybody. I'm Jesse Weber, and what a panel I have with me right now. Criminal defense attorneys Philip Hamilton and Dan Hochheiser are back with us. A lot to cover. We're going to talk about a brand new trial right now. Okay, so Philip, first let's go to you. Now, the defendant wasn't even initially arrested because the police said, well, he's protected under Florida's Stand Your Ground law. Then he's charged with manslaughter. What do you think about that?
In terms of the police not making that decision, I mean, I always have felt, just in the look at this video, that decision was wrong. I feel that was a decision that ultimately was to be made either by the state's attorney's office or someone with more of a legal background and an understanding of what exactly the Stand Your Ground law entails. The issue that I had with the decision that the sheriff made was that he de facto made almost an illegal interpretation that he believed to be final as to what exactly the reasonableness standard was, and basically all of the nuances that a lot of times you have to go into the case law to determine, particularly with respect to that Stand Your Ground law in Florida, because it's complex. Right. What concerned me was just with the complexity of that law, to just immediately just say, there's no case here, there's nothing to see here, goodbye, why are you all still yelling about this? Why are you all making such a hoopla about this? It wasn't that simple, and that's why everybody was making a hoopla, and that's why to this day I just feel as though that decision was wrong.
Well, now it's going to be in the hands of a jury to determine whether or not this was self-defense, Dan, and how do juries react to these kinds of self-defense cases?
Well, they look at them very carefully, and as the professor spoke about in that clip you played, this is a very fact-specific driven analysis where you need to know the particulars. Okay, so the defendant is pushed to the ground. Then what happens? Does the deceased continue moving towards him? Does he take a step back, as I think the professor alluded to alleviate the threat? So stand your ground doesn't mean you can kill somebody who's retreating. It doesn't mean you can kill somebody because they pushed you before and there's no threat to your life or serious physical injury. There has to be a present, imminent, reasonable threat to your to your physical safety or to your life. And if they can't show that, then this self-defense argument is not going to work.
Well, I'll tell you somebody who doesn't believe that this is self-defense, and that's Sue Ann Robinson. She represents the victim's family. She spoke out as well. All right, that wasn't exactly how we wanted to play that, but it's fine. Clearly, there's another perspective here. Is this, you tell me, is this a subjective standard? Is it, okay, now we have to put ourselves in his position. What was he thinking? What was he feeling? Or is it objective? What would a reasonable person would have done? Because this is an interesting situation from a different angle, and especially the fact that it is captured on surveillance footage, so we're all going to have a chance to see it.
I mean, it's an objective standard, but, you know, Dan will sit here, I'll tell you, the objectivity is still kind of peppered with subjectivity because the jurors have to, basically in determining what the reasonable objective person will do, they're still always at the end of the day going to be thinking about how would I have handled myself in that situation. Even if legally they're not supposed to, it's going to happen, Jesse. And so to that extent, when you kind of look at the situation that happened here, Dan hit the nail on the head when we talk about this standard being one of reasonableness. And to the extent that you have, the victim here stepping back. And, I'd actually like to take just one moment to just kind of contextually explain what even initiated that encounter in the first place. You have the defendant that's out there yelling at the victim's girlfriend. The victim was pregnant. The victim had 2 or, I believe, 3 kids in the car, that she's dealing with this irate, fake wannabe police officer person. The defendant had to come out and ultimately, defend his family. And so I think just that push, I don't even find that unreasonable, just to the extent that you just want to be able to defend your family from basically this nut. But then to the extent that you did that, whether one wants to look at that as reasonable, unreasonable, the minute that he took that step back, whenever that gun came out, as the professor from your alma mater said, the threat was neutralized. And so at that point, I don't see any objective or subjective reason as to why he had to fire that gun, and I think it's going to be a tough case for the defense.
So then what's the counter perspective? You're the defense, you call it an expert witness. What would be the ideal testimony that you would want for this jury to hear?
There would have to be some fact that defeats this fact that seems to show retreat, okay? Where was he going? Was he going to get a weapon? Was he taking a step back for some aggressive reason, even if on the tape it doesn't appear that way. Did this defendant who did the shooting know something that is not apparent from the tape? So I think that's what you have to look for, some other circumstance that perhaps we'll learn about at the trial, which explains the defendant's conduct and supports a self-defense argument.
You had said earlier, Philip, that it's a complicated case. I mean, these are complicated issues when you talk about stand your ground. So if you could just make it illustrate a little clearly for us. I mean, look, the sheriff's department originally said he was protected. They passed that decision to the district attorney's office. They determined that this is a question that has to go now to the jury. So what would be the ideal case, a textbook law school example of where you can say clearly stand your ground applies here and he should not even be brought up on any charges? What would be the clear-cut case?
All right, fine. Let's take the facts of this case, right? So we don't even have to start bringing in, all kinds of, outside abstract situations. Let's take a look at this case. Let's presume that when the victim was on the ground, at that point, you could somewhat almost say defenseless. And instead of making that retreat, let's say, I'm sorry, the defendant was on the ground.
Right.
Let's say that the victim then made a hard step towards the defendant, like a hard step, 2 hard steps. Maybe we see some eccentricities with respect to his arms. He's yelling. That's the kind of point where in that situation, if he fires, he has a pretty good case. I mean, I don't even know if that one comes out of, sorry, Jesse, I don't even know if that one comes out of the pretrial litigation, right? Like there may be a situation where on the law in that point, the judge just determines, you know what, like you had the right to stand your ground at that moment. You were on the ground in a defenseless position. This person who had just pushed you, quite hard is now making an aggressive, approach towards you. Basically what Florida is saying is that you don't have to wait and see what's going to happen once that person makes the approach and comes into contact with you. You don't have to wait and get punched in the nose. You don't have to wait and get kicked in the head. You don't have to wait and see. You can stand your ground and protect yourself. The question there still would be like, was the use of force reasonable in the sense of somebody was charging you without a weapon and you pulled out a weapon and then, basically brought a gun potentially to a fist fight? But if the defendant at that point could make the showing that I didn't know if he had a gun, I didn't know if he had a weapon, and I didn't want to wait and see. I stood my ground, I was protecting myself, and I shot. I think, Jesse, he'd have a much better case, and that would be closer to the textbook scenario that you're asking for.
Dan, does it also matter in terms of what the intent was here? If you have somebody who takes out a weapon and then shoots somebody in the shoulder just to stop the threat, as opposed to I'm going to kill this person. Does that play in as well? Because as we watch this video, I'm wondering if that's something that's going to be explored. Maybe his aim, I don't know how good of a shooter this guy was. I don't know if he was aiming for the shoulder, was aiming for something just to stop, neutralize, maybe fire a warning shot as opposed to hitting him right where he did.
It definitely matters. The intent matters. And one of the things about self-defense, or what we lawyers call a justification defense, is you have to show that you were justified in doing what you did. So that's why Philip and we're discussing all these subtle details about who was where, when, and who pushed who, and was he taking a step back, was he taking a step forward? As I said earlier, was he going to get something? Did you think he had a weapon? Did you know he didn't have a weapon? All these facts matter so much in this very sensitive self-defense context, where you really have to show on an objective basis that what I did to shoot the guy and kill him was necessary to protect myself or somebody else.
I kind of want you both back when this case starts and we can debate it some more. These are excellent perspectives on what can be a very complicated case. So we are going to cover that starting on Monday. Maybe we'll have a chance to talk a little bit more about it later on today. In the meantime, we'll take a break. When we come back, we have to revisit the Eric Boyd trial. Stay tuned.